Good afternoon. Can you hear me?
There we go.
Yep.
Okay, perfect. All right. Well, I apologize for the glitch. It's not a webinar unless you have a last-minute issue with Zoom or GoToMeeting. But good afternoon and welcome to our webinar. My name is Andy Jimenez. As Eileen mentioned, I'm the Senior VP of Risk and Trust Operations for Egis Insurance and Risk Advisors. I see that we have about everybody joining us. So I know a lot of you are joining us during your lunch hours, and I want to be respectful of your time. So we'll go ahead and get started. We did open up this webinar to both FIA members and non-members. So I wanted to give a special welcome to our valued FIA members. But before we get to the meat and potatoes of the webinar, I do want to take an opportunity to give a brief introduction of our firm to those that might not be familiar with Egis or FIA. But Egis, we're the trust administrators for the Florida Insurance Alliance, better known as FIA. And FIA is a governmental self-insurance trust that is organized under Florida Statute 624.4622. And we provide property and casualty insurance as well as other risk management services to over 800 local governmental entities and public charter schools throughout the state. We have a very diverse membership, but we do specialize in special taxing districts and public charter schools. We provide insurance to close to 200 public charter schools and work with over 600 special districts from the Panhandle to the Keys. And one of the many lines of coverage that we offer is employment practices liability, often referred to as EPL or EPLI. And that's the reason why we're here today. With the COVID pandemic, a lot of employers across the state had to quickly develop and implement policies and procedures and had to make some difficult and significant decisions in what clearly is a very fast-moving landscape. Not surprisingly, we're starting to see some COVID-19 related lawsuits being filed against employers. So in an effort to provide our membership with some guidance and to help them navigate through these waters, we partnered up with the newest member of FIA's panel council, law firm of Weiss Serota, to bring you this webinar, which I hope will answer many of the questions that you may have. I've already taken too much of your time, so let me introduce our guest of honor, the meat and potatoes. Brett, I'm sure you've never been introduced that way, but he's a partner and the chair of the Labor and Employment Division. I was planning to go over his CV, but it would take me about 5-10 minutes to go over all his accomplishments. So we will make the CV available as a document that you can download. So this is some of the things that we asked Brett to cover today: the Family First Coronavirus Response Act, FMLA, COVID, how FMLA responds to COVID, layoffs, accommodations, telecommuting, and we'll have a Q&A section at the end. So we've got enough content for about 3 hours. We're trying to condense everything into 45, 50 minutes so we can have some time for Q&A. So Brett, if you want to take it over from here.
Sure, sounds good. Can you guys hear me?
Yeah.
Great, awesome. So good morning, or I guess good afternoon, everybody. As Andy indicated, I'm Brett Schneider. I'm a partner with Weiss Serota Helfman in Boca Raton, and I want to thank Andy and Eileen for inviting me to present today. It's an honor and a privilege, and we appreciate the partnership with Egis and to work with them and to assist you guys going forward. So I guess I should start by saying, as many of you on this call who have roles in HR know, during the last 5.5 months, those in the field of human resources or those in the field of labor and employment law really have been drinking from a fire hose. I have been practicing labor and employment law for 20 years, and I have never experienced a period professionally like I have over the last 6 months. I mean, obviously, putting aside the professional aspect, it's been obviously a wild ride. 2020 has been like no other year in any of our lifetimes. But from a professional perspective, the amount of nuanced and unique issues that we've had to address in a short period of time is really unprecedented. And like I said, it's just been a really chaotic period of time. And so for those of you who practice in the area of human resources, I know you can commiserate. And I would tell you anecdotally, before I get into the meat of this, I do a lot of speaking throughout the state, and I was actually up last week in Orlando at the HR Florida conference, which surprisingly, they actually did do, at least in part, live, which I think was probably one of the first conferences that had tried to do that again post-COVID. And I did a presentation there with the plaintiff's employment lawyer. And we've done it before, and the idea is sort of what employers need to know from a plaintiff's perspective, the kinds of things that lawyers that sue employers look for. And we literally spent the entire hour focused only on potential claims that employees can bring against their employers that relate to COVID or that relate to the circumstances surrounding COVID. And I tell you that because I think it's a good segue into what we're going to discuss today. The idea being that, because of the novel issues and because of the various laws that apply to the various aspects of COVID and what we're dealing with, there is so much potential exposure for employers. And I, again, don't mean to scare you or don't mean, for you to lose your appetites over lunch, but as many of you probably know, there are just so many issues that you need to be aware of and concerned about, and that you need to be proactive about. So I kind of wanted to preface the discussion with that. I know as a housekeeping matter, Andy had indicated that we'll do some Q&A at the end, which is more than fine. I don't know if you guys want to use this also, but if you have a question as we go on and you don't want to lose track of it, I know that Zoom has a chat feature where you can type a question in, and so I would certainly invite you to do so if you don't want to lose track of those questions. And if I see those questions in the chat, I can certainly try to weave answers in also throughout the presentation where they're relevant. So with all that being said, this initial slide gives you an overview of the first set of issues I wanted to discuss, which is leave under the Families First Coronavirus Response Act. And for those of you who, again, practice in this area, who are in human resources, it's very, very fascinating legislation that was adopted. And I say fascinating because, essentially Congress adopted the legislation in March, and it became effective for employers April 2nd. And I can tell you, again, having practiced in this area for 20 years, normally when Congress adopts laws, any kind of law, but really laws affecting employers, whether it's wage and hour laws or non-discrimination laws, there's typically a significant lead up for employers to comment on the laws and to play a role in sort of with lobbyists to shape what the laws look like. And then even when laws are adopted and signed into law by the president, plenty of time for employers typically to sort of get their arms around it and have an implementation plan. Well, as all of you know, you can all throw all that out of the window when it came to the Families First Coronavirus Response Act. Literally, by the time the law became, signed into law by the president, employers essentially had like 10 days to prepare, and which, again, fascinating and really unprecedented. And we were being, frankly, asked questions, unique questions about this before there was even any guidance on it. So hopefully most of you have had some time now to react to it and have had, the ability to implement a plan. But, I think what's important for you all to understand is that while that was adopted back in April, and I think a lot of employers had issues that applied immediately, the law is effective through the end of the year. So you need to continue to be aware of the law and its ramifications. And so I'd like to just spend a few minutes going through the law and how it applies. So first, the law provides two types of paid leave: emergency paid sick leave and emergency family medical leave. With respect to emergency paid sick leave, what the law says is that employees who fit into one of 6 different categories are entitled to up to 2 weeks of either completely or partially paid time off. The categories for the emergency paid sick leave are the following. Category 1, the employee has to have been subject to a federal, state, or local quarantine order or isolation order that relates to COVID-19. So those are probably less applicable now, but they were obviously very applicable back in the spring and early summer. Category 2, an employee who has been advised by a healthcare provider to self-quarantine related to COVID-19. And I say related to COVID-19 because you don't necessarily have to have a confirmed diagnosis But if you sought treatment and your doctor said you may have it and you need to self-quarantine, then that would trigger rights under the Act. 3, an employee who is experiencing COVID symptoms and is seeking a medical diagnosis. Again, this is somebody who hasn't necessarily been confirmed to have it, but who may have it and is seeking treatment. 4, and this is really, 4 is if your employee is caring for somebody who is subject to one of the first couple of categories, that they're caring for somebody who's got COVID or may have COVID, or who is subject to a local quarantine order. 5, and this is really the most significant one, and I think is the most prevalent and relevant as we continue to move forward. If an employee cannot work because he or she has childcare responsibilities, because his or her children or child do not have school or daycare to go to due to COVID. And then 6, and this is kind of vague and we're not really sure exactly what this is supposed to mean, but if an employee is experiencing any other substantially similar conditions specified by the U.S. Department of Health and Human Services. And that's kind of a catch-all. I haven't really seen that come into play yet, but essentially, as you can see, this is pretty broad, and any employee who fits into one of those categories is entitled to 2 weeks of protected paid time off. Now, I should add, it gets a little bit complicated. If your employee qualifies for one of the first 3 reasons, that they're subject to a quarantine order, or that they are self-quarantined or experiencing symptoms and seeking a diagnosis, they would be entitled to 100% of their pay, capped at $511 a day, or $5,110 for the total period. Again, it's 2 weeks, which is 10 business days. So that's why you get 511 times 10. If you fit into one of the latter 3 categories, and again, the most significant of those categories being that you have school-age children at home, the pay is 2/3 of your pay, and it's capped at $200 a day, up to a total of $2,000. So that's essentially the emergency paid sick leave component in a nutshell. Now, the emergency family medical leave component, and we'll talk about family medical leave in a moment, but this is a special provision that only applies to family medical leave or family leave that's required, again, because an employee's child is at home and needs to be cared for. So for the emergency family medical leave component only covers that one category that is also covered by the paid sick leave component of employees who cannot work because they have to be home with their children. And for those employees, in addition to the 2 weeks of emergency paid sick leave, they get another 10 weeks of emergency family medical leave under the same terms. In other words, they continue to be eligible for the 2/3 pay. So it's really up to 12 weeks at 2/3 pay with those caps. So, those obviously are significant buckets that you need to be aware of. An employer, hopefully you have, and if you haven't, you should make sure that you notify employees of their rights. Actually, one of the components of the law is that you're supposed to post, in a place where you post other employment-related posters in the workplace, a notice regarding rights under the law. I know back when this all came to be, a lot of employers did not have in-person operations, and some do now, some don't. What we advise clients at the time is, to post a notice in a workplace where nobody is doesn't really provide notice. So we were advising employers who were largely remote to make sure that notice was sent via email or otherwise made available or accessible, so employees had knowledge of their rights. So that's an important piece of this. Eligibility, I've covered the categories of eligibility, but the other thing I wanted to mention was that this act only applies to employers with 500 or less employees. So if you have over 500 employees, congratulations, you don't have to concern yourself with this. There is also, while it applies to all employers with 500 or less employees, there is, if you are a small employer, and this may not apply to any of you, but if you are a small employer, which is defined as having 50 or less employees, you are not mandated to comply. What the Department of Labor has said, which is the agency that is responsible for overseeing the law, is if you want to opt out because you have 50 or less employees, there's a small business exemption. You don't have to apply for it, but you do have to document why compliance with the law would create an undue hardship for your business. And the idea is really that if you comply with this law, it would essentially render your business unable to operate. So, for example, if you had a small, I know there's a lot of educational institutions, if you had a really small school that had, only a handful of staff and all the staff had school-aged children, an employer could say, well, if we complied with this law, that would essentially mean we could not operate because we'd have the potential to have all of our employees take leave and we wouldn't have the ability to operate. So under those circumstances, a small business could opt out. Reimbursement for leave, and this is a big one. And this is, I had employers, client employers contact me back in late March, trying to come up with strategies to avoid having to comply. So, I would have, and of course I won't name the employers, but I would have employers call me right before implementation and say, hey, we'd like to do a layoff, and we're thinking about laying off any employees who we think might be eligible for leave under this law. And, and I would chuckle and say, well, first of all, you may have an interference claim on your hands if you do that. But more importantly, for most employers, complying with this law should not impose a financial burden. And the reason is because for all private employers, now this doesn't apply to public employers, but for all private employers and that are for-profit businesses, you are entitled to a dollar for dollar offset for all paid leave provided under the law from the federal government. And the way it works procedurally is, and this is something you probably need to talk to your your payroll or your accounting folks, is you take it as a credit initially off of the FICA deductions that you submit to the federal government, and if for all of your workers, and if the amount of paid leave exceeds all of that, you can then submit a request for reimbursement of anything paid in excess. So again, it's something that this law was intended to protect employees who were burdened by COVID. Like a lot of employment laws, it's intended to be applied liberally to ensure that employees are protected. And because it's a new law and because employers had very little time to prepare, I anticipate, and I think a lot of employers that practice in this area anticipate, that we will see a lot of litigation arising from this law and from either lack of compliance or inadequate compliance. And what I would note is, like a lot of employment laws, that this is going to be a law that the plaintiffs' employment lawyers, those that represent employees, are going to really look for opportunities to pursue claims under, because A, they're aware that a lot of employers didn't really have time to prepare for it, but B, and perhaps more importantly, this law provides liquidated damages and prevailing party attorney's fees, which basically means that they can sue you, and even if it's a small dollar claim, if they prevail, they're entitled to have their entire fee award paid for by the employer. So again, this is something that hopefully you all have had time to sort of ramp up with and have an understanding of. It's not overly complicated, but again, there are pitfalls if you don't comply. And as a practical matter, what I have advised employers to do, and hopefully many of you have already done so, are to adopt, make sure your employees all have notice, adopt some sort of a policy or written protocol for how it works in your agency. In other words, who you apply, who you go to apply. We've created forms for our clients to use. So if you want to take emergency paid sick, it would ask you under what category are you eligible, and whatever other information that would be pertinent to confirm eligibility, and to have a process through which those forms are processed and accepted by the employer. So those are really critical issues. And again, I wanted to just briefly touch on a few unique issues that may or may not be applicable. And what was interesting, as I mentioned earlier, when the law became effective, I was getting unique questions before we could get any guidance. And fortunately, back in right around the time the law was implemented, the Department of Labor issued a very comprehensive questions and answer report that tried to proactively address a lot of questions that employers were raising right out of the front end. And while these aren't binding, courts could construe the law differently. These are a good sort of roadmap for employers to follow to make sure they have no issues. And so I wanted to just highlight a couple of these real quickly that I thought might be of particular interest to the group here. One of them is, getting back to the primary category that's probably of interest to most of you, the I can't go to work because you have to take care of my child. So, I'm down in South Florida, and obviously what we're seeing down here right now is in Dade, Broward, and Palm Beach counties, the public school districts are still only virtual. We have private schools down here that have opened, or at least opened in part, and you have, but there's a lot of talk about the potential at some point, later in the spring, later in the fall, that some of these schools, public school districts, may open and may have an option. And one of the questions that's been raised is, what if as an employee, your child's school or daycare opens, but there's an option to either send in person or to stay at home? Could the employee choose to have their kids go to school virtually and take advantage of the leave? And again, no cases on this point, but what the DOL has said, and I think is correct, is that if the employee has the ability to work, has the option to send their children to school, and chooses not to, the employee would not be in a position to take advantage of the leave. So I think that's one issue that's of interest, especially as you look at situations where many schools are going to have options to whether to go or not to go. So that's one thing I wanted to raise. Another thing, for those of you who are familiar with the Family Medical Leave Act, you would be aware that Family Medical Leave Act, the regular Family Medical Leave Act, allows for the use of intermittent leave. So if somebody has a health condition, they don't have to use all their leave at one time. They could take it intermittently. And so one of the questions that's been raised is, can employees use leave under this act intermittently, or must they do it in a block? And what the Department of Labor has said is it's really at the option of the employer. But you need to take a position and apply it consistently. So again, this is one of those things that you're going to have to sort of evaluate your workplace and figure out what works. I'll give you an anecdote on this that, for my own law firm, I have a legal assistant who's excellent, who's a single mother and has joint custody with her ex-husband and has her child every other week. And it's really difficult for her to be able to work from home in her capacity as a legal assistant, where a lot of her job is answering phones and other things that can only really be done in the office. So what we've done with her is she's working every other week, and then her weeks when she has her son, she is taking leave under the both the 12 weeks under both the emergency paid sick and emergency medical leave, and that way she can get at least partially paid through government subsidy for every other week while she works every other week. And another thing I would add, because this has been asked a lot, is some employers say, well, we understand the main component of this is the taking leave to take care of a child, but it's only 2/3 of their pay, and it's capped. What if we wanted to, help the employee out? Could we make up the difference? And the answer is, of course you can. I mean, you can either, if you have accrued paid time off policies, one option would be that you allow them to burn accrued paid time off to make up the difference. But you don't even have to do that if you're in a position where you have the ability to make an employee whole. You could theoretically pay the 1/3 yourself. Now, only the 2/3 under the law would be reimbursable from the government. The other 1/3 would be on the employer, but you certainly could handle it that way. So, and as Andy alluded to at the beginning, this is just the first topic. I could probably spend an hour on this alone, but I do want to cover other grounds. So let's move on to the next topic. So application of FMLA to COVID-19. So, we just spent 25 minutes talking about the Family First Coronavirus Response Act and the fact that it has its own emergency FMLA provision, which deals just with people who need leave to take care of a child who's at home and has no school or daycare. Well, one of the things that some employers have sort of lost track of is they're so focused, a lot of clients are so focused on that they forget that there's this full FMLA that may apply in certain situations. And again, I don't want to spend too much time in the weeds on the FMLA, but I guess just to give you a little bit of an overview to give context, as probably most of you know, the FMLA generally applies to employers with 50 or more employees, and it generally entitles employees who have worked for the business for at least a year and who have worked at least 1,250 hours in the past year. It allows them up to 12 weeks of FMLA protected unpaid leave. And so I bring this up because, you have to be mindful of the fact that FMLA protects employees either due to their own serious health condition or to the serious health condition of an immediate family member. So of course, if somebody actually has COVID, there's no question that having COVID in and of itself would constitute a serious health condition under FMLA. So like if you think back to the Families First Act, and we had a couple categories of emergency paid sick, which essentially covered somebody who was either quarantining or self-isolating or seeking treatment for COVID. Even once those individuals, if they actually have COVID, exhaust the 2 weeks under emergency paid sick, they would still be entitled to additional leave, albeit without pay, for up to 12 weeks under the FMLA. So it's important not to lose sight of that. So let's just use a hypothetical to sort of shed some light on this. So let's say you have an employee who gets ill, calls in, says, "Hey, I'm really not feeling well. I have a bad cough. I have a fever. I just got a COVID test this morning. They told me it's going to be 4, 5, 6, 7 days before I get a result. My doctor told me I should stay at home." What would happen in that situation? So first of all, that employee would absolutely have the ability, effective immediately, to take their 2 weeks of emergency paid sick under the Families First Act. Let's assume that that at the end of that week, they get a confirmed positive diagnosis on their COVID test. So let's say they continue to stay sick and remain symptomatic, they would be able to continue with their emergency paid sick for the remainder of that initial 2 week period. And if they continue to be positive for COVID or be symptomatic after the expiration of the 2 weeks, they would continue to be eligible for additional leave time under the FMLA for up to another 10 weeks, because we would count the first 2 weeks of emergency paid sick as counting toward the 12 weeks of FMLA, but they would theoretically have up to a full 12 weeks to take leave. And when I say leave, protected leave, in other words, you can't let them go and you can't, give their position away for up to the full 12 weeks of time. So it's an important thing not to forget. And again, not only does that apply to the employee, him or herself, but again, let's assume that employee, let's change the facts and assume instead of the employee being sick, the employee calls in on that initial day and says, "Hey, my husband is symptomatic and is going for a test," or "my daughter or my son," same analysis, because FMLA provides protected leave for an employee, not just for their own serious health condition, but to care for an immediate family member with a serious health condition. So again, be mindful of the fact that even if somebody exhausts their 2 weeks under FFCRA, if or their family member is sick and diagnosed with COVID, they would continue to be able to avail themselves of FMLA rights under the FMLA. And again, sort of same thing I mentioned earlier. The FFCRA is really like an extension of FMLA from a legal perspective. And what I mean by that is, let's take one of my hypotheticals, and let's say an employer unwittingly fails to properly comply with either or both acts under the FMLA, just like the FFCRA. An employee has the ability to pursue litigation against an employer, both for whatever it was that he or she was entitled to and didn't receive, but also liquidated damages as well as attorney's fees. So again, it's important to be mindful of this. And again, I think one of the things I wanted to add, and I could have said this at the beginning, that we're talking about the law here, and we're talking about sort of what the legal requirements are, but there's a whole other aspect that I think most employers are cognizant of and they need to be mindful of, which is, I'm telling you what, as a matter of law, you have to do, but there may, depending on your industry and depending on the circumstances, that may not be enough from like a policy or public relations perspective. I mean, saying, telling somebody who got sick from COVID and who's potentially very ill, that here's your leave, and after we're going to put you on unpaid FMLA for 10 weeks, that's all you're legally required to do. But, might there be public pressure on you to provide a greater benefit, to continue to pay the employee while they're out, even though it may not be required? These are just the types of things that a lot of employers have had to grapple with Because again, this is something that, even those people who have been as safe as possible and socially distanced, it's, people in all sort of different walks of life and in all different sets of circumstances have gotten sick. So again, just something to be mindful of as you think through these issues. Now, if we can move to the next one. Great. Another big one, this one is actually a lot simpler than what it might first appear to be. One of the questions that is posed frequently is, well, what happens, or do I have liability if I make my employees come to work and somebodies get COVID and they try to pursue a claim against my business, against the employer for contracting COVID in the workplace. So there's two aspects to this. First of all, as those of you who again practice in this area know, we have workers' compensation laws, and those are state-based laws. But basically, what workers' compensation does is it provides an exclusive avenue for employees who get injured or ill on the job to pursue a claim under. Employers pay for workers' compensation insurance, and what employers get in return is that if they are properly complying with workers' compensation law, what it does is it provides employers with immunity from tort liability from employees. So what that really means is that if you have a sort of run-of-the-mill, let's put COVID to the side, a run-of-the-mill workplace injury, let's say that you own a factory and you have an employee who does a lot of manual labor and falls off of a ladder on the workplace and fractures his arm. The way that would work is even if the employee could claim that maybe there was some negligence associated with that you guys didn't properly secure the workplace, the employee could not sue the business directly and say, hey, I broke my arm because of you and I want damages, et cetera, et cetera. The employee's only real recourse for that would be to file a workers' compensation claim and to go through that process. So, again, we're early on in this, and there have been some lawsuits that have been filed directly against employers. But my read on this is that what would happen is if an employee believes he or she contracted COVID at the workplace, really what they should be doing is filing a workers' compensation claim. If an employee tried to file a direct lawsuit against an employer claiming, hey, I got COVID because of the workplace and, I want damages, an employer really should be moving to dismiss that claim on the basis that it's got to go to workers' comp. Now, the other interesting wrinkle on this, and this is something that I think is not going to just apply to COVID claims in the workplace, but any type of claim against any entity where somebody says that they got sick because they were exposed at a certain place. The trick here is going to be that individuals who make those types of claims are going to have a really difficult time proving causation. In other words, proving that the reason that they got COVID was because they were at work, or the reason they got COVID is because they went to restaurant A. The problem is COVID has become so widespread, especially here in Florida and in South Florida in particular, that it's virtually impossible for somebody to actually prove how they got it. Now, look, could there be a hypothetical case where somebody was strictly social distancing and basically said they never left their home other than one occasion, and so, but for that occasion, they wouldn't have gotten it? I guess it's possible, but I think it's highly, highly unlikely. So I guess the big takeaway on this particular issue is, although at first blush it may seem like something to be concerned about, I think from an employment law perspective, it's probably not something employers have to really lose much sleep over for the reasons I just stated. What I would also add to this is, what employers, despite what I've just said, employers should be using common sense. I mean, a lot of employers who had the ability to let employees work remotely did so, and we're going to talk about that in a few minutes. But to the extent that you have employees in the workplace, a lot of it's just common sense, following sort of CDC guidelines and other common sense guidelines to try to provide as safe a workplace as possible. Things, as we all know, things like requiring people to wear masks, having hand sanitizer readily available, implementing social distancing requirements in the workplace, trying to prevent in-person meetings unless absolutely necessary. All those types of things, I think are good common sense, will provide your employees some sense of safety, and will also make it less likely that you'll have any potential issues or claims. Although, like I said before, I'm not all that concerned about those claims for the reasons I just mentioned. Can we jump to the next slide? Okay. Layoffs, furloughs, RIFs, which is an acronym for reduction in forces, and pay cuts. So, sadly, a lot of employers have had to do one or several of these things over the last 6 months due to obviously budgetary issues. I represent a couple of schools. I represent a couple of not-for-profits that have daycares and childcare, and obviously they're not immune. I mean, when entities were in a position where you didn't have students, going to school, a lot of them can't continue to pay people or continue to pay people at the same level when they really have no meaningful work to do. So a lot of employers have really looked at implementing one or many of these cost savings protocols in order to gain relief from the economic imposition of COVID. So that's sort of the background. On the potential exposure, layoffs, furloughs, RIFs, and pay cuts are not pleasant. Obviously not pleasant either for the employer to have to do, or obviously for the employees that have to be exposed to those. But if done properly, there really shouldn't be a whole lot of exposure. And when I say if done properly, and what I mean by that is, there needs to be a thought put into this. If you're going to do a layoff or a furlough, for those of you who want to know what, I've been asked a lot, what is a furlough? What is the definition of a furlough? And it's funny because it's become an interesting term in that it means different things to different people. I think the conventional sense of what a furlough was essentially a layoff that was temporary in nature, where there was an expectation by the furloughed employee that they would have their job back at a certain, perhaps non-specific date in the future. But I also have some employers, some clients of mine have implemented furloughs where people continue to work, but maybe they work 4 days a week, and the 5th day a week is a day off without pay. So it means different things to different people. But the point here is that any of these things is probably not all that risky, as long as, number one, you can justify why you're doing it, which for most employers, based on COVID, is probably going to be relatively easy. Most employers, you can point to your an Excel spreadsheet or your budget to show that a lot of employers' revenues have declined precipitously, and so they have to save money. Number two, and probably most importantly, is to, if you're going to take action that's not uniform across the board, which, so let's go in reverse order. Pay cuts. If you're going to do pay cuts across the board and everybody in an organization is going to get an X% pay cut, it's probably pretty safe, because you're not going to be exposed to a claim that you treated, so-and-so differently than so-and-so for some discriminatory reason. But, if you do a pay cut that only applies to some segment of your workforce, that could bring about exposure. They could, those people that got impacted may try to argue that there was some, discriminatory or retaliatory or nefarious reason for the pay cut. So again, if you're not going to do a pay cut across the board, make sure that you can justify, why you did it in a non-discriminatory way. So one example might be, and I know some of my clients have done this, they said, well, we're not going to cut pay of people that are lower paid, because those people live more paycheck to paycheck. So, if you make $50,000 a year or less, we're not going to cut your pay. If you're making between 50 and 100, we're going to cut your pay 10%. If you make over 100, we're going to cut your pay 15, 20%, something like that. At least it's objective, and it's less likely to be, attacked for discriminatory motive. But if there's no rhyme or reason, and you just go around and you say, hey, your pay is cut, and hey, it's not, you're going to potentially put your organization in a situation where, the person whose pay was cut could say, well, I don't know why they cut mine and not his. It must be because I'm a woman and he's a man, or it must be because I'm white and he's black, or I'm Jewish and he's Christian, or whatever it might be. So that's something to be mindful of. That same thing applies to layoffs and furloughs and reductions in force. When you are conducting any kind of layoff, whether it's permanent or temporary, there really should be some objective analysis used to determine who is impacted. And I tell my clients to do this, not only to have an objective analysis, but to put it, draft some sort of memo to file that's contemporaneous with this, that hopefully you'll never need to rely on. But if God forbid you get sued, you can go back, because memories fade, and you can go back and pull the memo, and it can really, hopefully give you a very clear picture as to why you did what you did. and so as you look at a layoff, furlough, or a RIF, it's the same sort of analysis. Figure out, is it specific to a certain job description? And if so, is it, try to use something objective, whether it's seniority, years of service, performance to the extent that it's quantifiable in evaluations, some kind of metric or criteria that if you're sued, you can say, well, no, it wasn't meant to impact a certain ethnic or racial or gender group more than others. It was done by this objective analysis, and this is just how it played out. So one other thing I recommend when you are going to do a layoff or furlough or reduction in force is, even once you have an objective analysis, do what we call sort of a post analysis, impact analysis. And what I mean by that is, sort of run through your criteria, and then look at, take a snapshot of the employees that are actually going to be impacted by the layoff, furlough, or RIF, and try to do sort of what we call a disparate impact analysis of that. In other words, try to see, does the composition of the people that are going to be impacted by the layoff, furlough, or RIF, does it sort of generally match the composition of the workforce overall? In other words, if your workforce is 50% under 40 years of age and 50% over 40 years of age, you'd hope to see that when you run through your analysis for your layoff, that the people being laid off, it doesn't have to be exact, but at least there's a correlation that it's close to 50% under 40 and 50% over 40. If you run through an analysis and you have 50% under and 50% over, and every single employee slated for layoff is over 40, I can tell you with certainty that you're going to get sued, and they're going to claim that whatever approach you were using, there was clearly, whether it was intended or not, there was clearly an impact, a really adverse in not proportionate impact on older workers. And so the same thing, that's really the main issue, is age-based claims, but any minority group could make a claim if the composition of the folks being laid off does not, at least in some respect, match the overall composition of the workplace. And lastly, I would say, if you're going to do any layoff or furlough or reduction in force, and you have any available funds, I'm a big proponent of using severance agreements. A typical severance agreement could have a lot of different terms, but the real keys for the employer are that it would have a release, that it would, the employee, once they sign the agreement, could not sue you based on, the layoff or the furlough. What's important for severance agreements in the context of a layoff or furlough is the main category that employers are typically worried about is age-based claims, because that has traditionally been, sometimes employers have used layoffs to reduce, eliminate older workers. And there are special legal requirements for valid severance agreements for age releases. Just in a nutshell, without getting too deep in the weeds, generally, if you're going to do a mass layoff and you want older workers to waive their potential age claims, you have to give them up to 45 days to decide whether to sign the severance agreement. And even when they sign it, they have to be given 7 days to decide to revoke it. They also have to be given a list attached to the agreement of the positions that were eligible for layoff and the ages of each person in those positions, with who was laid off and who wasn't. Not the names, just the job titles and the ages. So, and the purpose there is so an employee who's presented with an agreement can look at it and can go to a lawyer and look at it and evaluate whether they think there's any age-based animus in connection with the layoff. And then finally, for a severance agreement to be valid and for that release to be enforceable, there's got to be consideration given from the employer to the employee. And generally speaking, that consideration is typically in the form of money, whether it's a certain number of weeks of severance pay tied to years of service, or whether it's continuation of payment for their health insurance or COBRA premiums, but some sort of consideration. A severance agreement where there's no consideration that just has a release is not going to be valid, and if challenged, would not be enforced. So let's move to the next slide. Accommodations for high-risk employees. So let's say, as we all probably have, you have employees who have not gotten COVID, but who fall into a category where, we think they're at special risk, whether they're over 60 or they have, cancer or diabetes. And, what do we do about those employees? And as we just, talked about, under the Families First Act, somebody who just has a pre-existing condition but has no symptoms is not going to be entitled to leave, and probably is not going to be entitled to FMLA unless that condition is worse, or they're having a flare-up. but what employers do have to remember is, those people may qualify for protection under the Americans with Disabilities Act because they may have a disability, like I said, especially not so much an age issue, but especially if it's a pre-existing condition, diabetes, cancers, those types of things that put them at higher risk. And so what do you do as an employer if you have a high-risk employee who says, look, I'm healthy, but I'm scared. And I'm afraid that if I'm forced to come to the office, I could get COVID and that could create a real, potential messy situation for me. I'd like some sort of an accommodation. And that accommodation probably in that setting is, either to be allowed to work remotely or allowed to work somewhere where they're not around other people. And just like you would in any ADA context, what an employer needs to do is go through your typical reasonable accommodation analysis, looking at the job duties of the employee, determining whether that those job duties can be reasonably performed outside of the workplace, and trying to fashion a remedy that might work. Employers are not required to accommodate if it's not reasonable to do so. If you have a school and you go to all in-person learning and a teacher says, you know what, I'm scared, I don't want to teach, I want to be able to, quote, work from home as an accommodation. Unless you have some sort of unique protocol in place, you would not have to grant that request. But there may be other circumstances where, let's say you have an administrative employee for your agency who can do 95% of their job duties from home. That it may be considered under those circumstances to be reasonable to allow that employee to work from home for some period of time. So again, I bring this up just because it's important for employers not to lose track of the fact that, even if you have otherwise healthy employees, if they have a pre-existing condition, they probably or likely have a disability under the law, and they may be entitled to an accommodation to the extent one's reasonable. We could jump to the next one. Okay, telecommuting. Again, there were a lot of fascinating issues that arose in this area, especially as we sort of pivoted back in March. And again, one of the things that made this so challenging is this kind of came on really quickly, as we all know. I mean, it went in March from, we're monitoring situations elsewhere to all of a sudden we started having a lot of cases in the US. And so very, very quickly, in a matter of a week or two, employers went from monitoring to the extent they could to shutting down their in-person operations and having people work from home. And unfortunately, because of that, employers who had not previously had clear telecommuting policies or practices, had to sort of quickly pivot. And a lot of them weren't really able to really adequately prepare for the legal issues that came from that. And so again, I think this is another area where we're going to see legal claims down the road. And I know we're running a little bit short of time, so I wanted to kind of focus on a couple of the big ones. First of all, workers' compensation. So workers' compensation benefits apply to any work-related injuries. So if somebody is working from home and they get injured, they would have access to workers' compensation benefits. So a couple of points I'd make there. First of all, it should be a non-issue, but you certainly should be reaching out, or you should reach out to your workers' compensation carrier or to whoever handles your claims to let them know, hey, we're going to remote operations in whole or in part, and we just want confirmation that your coverage is going to apply. It absolutely should, but I think it's just a good CYA to make sure you have something in writing, letting them know that you're going remote and confirming that the benefits will apply. I also think on the workers' compensation provision, it's important to make sure that you remind your employees, just like you would if they had a job-related injury at the office, that they're required to report those injuries to you timely so that they can be addressed. So again, reminding employees who may slip and fall at home, walking from their kitchen to their desk, that if they have an injury, they need to report it promptly. Security and confidentiality. This really goes to really more access to your computer systems. I mean, if you're not used to remote work, you do need to think about making sure that employees, that there's appropriate safeguards in place to protect employer confidential information or confidential information maintained by employers of their clients, customers, students, et cetera. So having some mechanism in place to protect that so that you're not liable for a breach of confidentiality that you may be protected from in the workplace because you have a sufficient firewall or other security measures, but may not be in place in a person's home. So that's one issue. Accountability, a little bit less of a legal issue, but a practical issue. I mean, making sure, how do you make sure that your employees, when they work from home, are working and are working meaningfully? And there's a lot of software out there that employers have looked into and purchased that track what employees do on their home computers during working hours to ensure accountability. No legal issue with doing that, although I would recommend that for employers who implement that kind of software that they make sure that they let their employees know so they don't have claims that there was some sort of breach of privacy, whether that breach is related to what websites they're searching, or I've even heard of some software that has a camera mechanism, like if you have a camera built into your computer that actually takes intermittent snapshots of whatever's sitting in front of the computer to just confirm that the employee's at their desk. So obviously, from a privacy perspective, you want to make sure if you're going to use any kind of tracking software that your employees are aware. Potentially the biggest issue with telecommuting is the wage and hour issues. As most of you probably know, you have the Fair Labor Standards Act, which is the law that requires employers to pay the minimum wage and overtime for all hours worked by non-exempt employees. Exempt employees, they can work as many hours as you need them to work at a regular salary. And so the question is, if you have non-exempt people working remotely, you really better have a way to track their hours and to make sure you're paying them properly, because FLSA suits, wage and hour suits, are really challenging for employers, because if you did not pay your employee properly, they're entitled to all of the unpaid minimum wage or overtime doubled and their attorney's fees. So again, when you're in the workplace, most employers have some sort of method for non-exempt employees to clock in or clock out, whether it's they walk in and there's a push button or a card, or they log into a computer, but it's a lot more challenging when it's done remotely. So you need to make sure that there's either some sort of log in or log out on a computer, or there's some sort of timekeeping system that accurately tracks time so that you don't find yourself in a position where an employee says, you know what, I was working 80 hours a week from home and I'm entitled to all this overtime. And the way the FLSA also works is there's a duty on the employer to keep accurate records. And so if the employer fails to have accurate records, whatever the employee claims to be true is presumed to be true. So again, that's a really important one, record keeping and making sure that employees are clocking in and clocking out and they're paid properly. And then finally, again, ADA, just like you do in the workplace, if you have an employee who's got disability related restrictions, they may have a need for accommodation even at home. And a good example would be somebody who has a back issue and who has a desk job, and who maybe they have a need for a sit-stand desk, and maybe they have one in the workplace. But if you do not, if they're at home and they say, hey, I can't sit at a desk all day, again, based on the the cost benefit analysis and other issues, you may have an obligation to accommodate. So I know I've said a lot. I've spoken quickly. There's a lot, as Andy indicated, we could spend hours on these topics. There's a lot of fascinating issues, and I know we're really running out of time. So I guess at this point, I'm gonna be quiet, and I know there's some questions in the chat room, and we can open this up for those or any other questions that anyone may have.
Brett, thank you very much. That was extremely informative. And it's a good webinar when you walk away paranoid. So we do have some questions. I know we're running a little bit out of time. I was wondering if we can go over 10 minutes over. Is that okay with you, Brett?
Fine by me.
Okay. All right. So the one thing I wanted to say, we do have a loss control questionnaire, which is what our loss control consultants use when they do the site visits. That can be very helpful for your organization to kind of have a self-audit. It goes over general practices, employee handbooks, recruiting, hiring, and onboarding. And if you want a copy of this, you send us an email for riskservices@egisadvisors.com, and we'll go ahead and send you a copy of this. If you find yourself answering no or NA to a lot of these questions, you can reach out to us. We have some resources, some training resources, some videos that will help your entity go from no to yes, hopefully. But Eileen, can you hear us? You mind reading out some of the questions that we received? Okay.
Sure. We have a question. If an employee that's requesting to work virtually, that they have a second job, that they work as much. They probably have as much or risk exposure as they would, let's say, working in a school. Are we allowed to ask about the second job?
Yes, and that's a great question. And one of the things we didn't really cover is what an employer's rights are in general in terms of either asking questions of employees or putting restrictions on employees regarding travel and outside duties and testing and those types of things. So yeah, I mean, if you have an employee who has got 2 jobs and they are asking to work virtually, but you know that they are working for another employer, you absolutely could take that into account in analyzing whether and to what extent to agree to the accommodation. And quite frankly, again, from a legal perspective, employers really have a lot of latitude with these issues. But again, what I think you have to do is balance the legal with the practical, and being mindful of the fact that hopefully we're in this COVID thing not for that much longer. Being optimistic, and if you have good long-term employees, you want to try to be flexible with them, even though legally you may have rights. You may want to be flexible so that you don't undermine good long-term relationships. But yeah, to answer your question, you can certainly take into account other employment in your analysis as to whether or not to accommodate an employee by allowing them to work virtually.
Okay. We also had a couple questions, Britt, in regards to when and how to have employees deduct days from their emergency paid sick leave. So for instance, an employee gets a negative result of a COVID test, but they still have symptoms. So the employer doesn't necessarily want them to come back just yet until they know for certain that they're fully recovered, especially in the case of schools and learning around children. Can the employer deduct those days from their emergency paid sick leave, or is that something that has to be initiated by the employee themselves?
So that's a really good question. Now we're in sort of an FFCRA advanced class, so that's a really good question. But yeah, I mean, look, and I think this is clear, but just to make clear, so FFCRA banked time, the emergency paid sick or emergency FMLA, is separate and apart from any banked time an employee has under your own policy. So I guess the question that's being asked is if the employee doesn't request the time off, but you're not going to allow them to work because of these issues, can you force them, I guess, to use FFCRA time? And I really think the answer to that question is it depends. And I say it depends because it depends on whether they truly fall within any of the categories under the law. I think if they do, you could. I think if they do, just like as many of you know with FMLA, if an employee is FMLA protected, and you think that they're eligible, you can sort of force them to utilize the FMLA leave to, and employers often do that because you don't want to have an employee out for an extended period of time. You want to burn their leave, and not that you're looking to get rid of them, but to get to a point where if they can't come back, you don't have continuing obligations to them to provide leave. So I think the answer really depends on whether they really fall into any of the categories. And so, depending on the situation, if an employee got is sick and got a test and the test was negative, but they're still symptomatic, I think you could absolutely have that apply. Now, I guess what's the more interesting question is, let's say an employee doesn't feel well, gets tested, the test is negative, and they're completely asymptomatic, and you're then going to impose on them some sort of a employer mandated prohibition on them coming back to work. I think then you wouldn't be able to force them to use FFCRA because it wouldn't really qualify, because it's not that the employee cannot work, it's that the employer is mandating that they not work. So under those circumstances, you'd have to either allow them to use paid leave under your own policies, or you pay them on your own, or however you want to handle it, but that would not be eligible for FFCRA paid time.
Okay. 2 more quick questions, and then just letting everybody know that if we haven't answered your question, we will get an answer to those questions and email you directly. So don't feel like we forgot about you. But a question that's come up a bunch of times is, can we force employees to take COVID tests or to
Yes.
submit to other type of testing?
Absolutely. So good question. Yes, the answer, typically, as most of you know, there are a lot of restrictions on medical and related tests that employers can force employees to take. It's actually considered a no-no under the ADA because it's, to the extent you find out medical information, that's problematic. But because of the nature of the global pandemic, the EEOC, that is responsible for overseeing and enforcing disability discrimination claims, has said the employers have broad latitude. So yeah, employers, you can absolutely have a testing requirement. You can, if somebody's out from work, for vacation or leave, you can mandate that they take a test and return to work. That's a legal answer. And I will tell you again, as a practical answer, for a while, and I think it's getting better, but for a while, it was really hard to get testing. And even when you could get testing, employees were waiting for a long time to get results. And so while legally you could do it, a lot of employers were finding it to be very onerous because it was, becoming a problem, because even when employees could come back to work, it may take a week or two before they could get tested and get a result. So I will also tell you that the CDC used to sort of advise employers that they could use either a test-based or symptom-based approach to employees coming back to work. Test-based approach being that, when employees out with COVID, have them take a test or two, get negative, and then come back, or symptoms that's just based on how they feel, not based on the tests. And the CDC is now, not that this is binding, but the CDC is now saying that the symptom-based approach is the preferred one. I think the idea being that a lot of the COVID testing has either proven to be unreliable or that there's too much of a delay in results that doesn't even really tell you the story. So the CDC is advising, and again, you're not required to follow this, but that you're better off as an employer evaluating an employee's ability to come back to work based on them not having symptoms for some period of time rather than them getting a negative on a test. But yes, you can absolutely have them test, and there's no lie.
Okay, and then obviously they have the test. They need to share the results of the test.
Correct.
To make to come back. Okay, last question is any restrictions that employers can place on employees as to travel or other off-duty activities that work to prevent the spread of COVID, but are off the clock?
Yeah. So again, great question. So again, employers, as a legal matter, have a lot of latitude. So if you wanted to impose a policy that says we prohibit employees from traveling to overseas, or we prohibited employees from traveling overseas, and if they do, they're mandatory that they quarantine for 14 days, and it's not going to be on our dime, and you're going to have to use paid leave. You can absolutely do that. Again, it's one of those things though that dovetails back into the legal, but also the practical. I mean, I think you want to try to fashion a policy that is both legal, but also shows some degree of sensitivity to employers. Like, I had a client contacting me actually yesterday, and the question was, can we, and they're based in Broward County, can we say that our employees are not allowed to leave Dade, Broward, or Palm Beach County? And I said, well, sure, legally you can, but it's not reasonable, right? I mean, there's no, what do you gain as an employer from that? I mean, what if an employee wants to go to the beach up in Daytona or Marco Island, or I don't know what you gain. And so even though legally you could, you're going to potentially upset a lot of people. I also had same client actually asked me, can we prevent our employees from traveling to Haiti or Jamaica? And I said, well, look, I'm not following the latest, guidelines, but if it's Haiti and Jamaica, I am concerned, and it's only Haiti and Jamaica, that you could inadvertently run into a claim of, discrimination, that you're discriminating against, people of color or people from Caribbean descent. So if you're going to have restrictions, but, only on certain places, there better be some connection to there being like a high, surge or high rates of cases in those areas. So it's not like, it doesn't look like you're just picking on certain types of people. But yes, you can absolutely have policies that prevent certain types of travel or that require quarantining, but you should just be careful, be intelligent, be practical, use common sense, and make sure that you're not treating people differently based on any, protected category.
Great. Thank you so much, Brett.
You're welcome.
All right, thank you. I apologize, everyone. We went a little bit over, but again, Brett, thank you. If you guys have any questions, we have our contact information on the screen. Of course, the dogs waited for the very last minute to chime in. So hope everybody had a great day. Again, thank you for joining the webinar. I saw that almost all of the attendees stuck with us to the very end, so I appreciate that. And Brett, again, thank you for hosting.
Absolutely. Thank you all for having me. Good luck. All right. Stay safe, everyone.
Have a great day. Stay healthy.
Thanks. Bye-bye.